Hello, Tom Street again. This is blog number 2, my first substantive blog on a particular point of law. And as I said in my introductory blog, I'm going to just try to focus in each blog on a particular point of law which happens to have arisen as part of my legal practice. So I thought the first point of law I'd focus on, which is something which I've had to research in some detail recently, is the legal test, one of the legal tests in unfair dismissal claims. The application, or part of the application, of what's known as the Burchell test, or the range of reasonable responses test. And essentially I've just come back from a case which was taking place in Leicester Employment Tribunal. The issues in that case were that my client had effectively admitted an act of misconduct. He had put his hands up and said to his employers, yes, what I did was wrong, and essentially in the hope that they were, I suppose, going to have some mercy on him. What he did wrong wasn't particularly serious, but could have been interpreted as a breach of the employer's very strict rules. I'm pleased to say we won the case, and the reason we won the case was not only because his employers failed to adhere to a fair process before dismissing him, and the reason that I think they failed to adhere to a fair process was because of his admission. They felt that, and possibly even took legal advice on this point, but they felt that having admitted the act of misconduct in question, they were perfectly able to simply put him through a very fast and unfair disciplinary process, whereby the disciplinary meeting itself, he was given very little notice of the disciplinary hearing itself, less than 5 or 6 hours notice. The disciplinary hearing was dealt with in a very cavalier fashion, no proper notes were taken, and he was dismissed within 15 minutes. This individual had in fact worked for the organisation for 22 years, but the case really focused on, apart from the procedural failings, the case really focused on the way in which the dismissing officer, or the person who dealt with his disciplinary hearing, the way in which he made his decision, and in particular the considerations, the extent to which he took into account mitigating factors. The main mitigating factor in my client's case was that for 22 years he more or less had an unblemished employment record. The reason we won the case is because the dismissing officer admitted in writing in his witness statement and during the dismissal hearing itself that he had no choice, and that's a quote, no choice, and his hands were tied. He effectively looked at the disciplinary procedures, which said, in this particular case, if you've done this, that means gross misconduct, and if you commit an act of gross misconduct, that means dismissal. What he didn't do was consider all of the circumstances and whether the dismissal was just and equitable in all the circumstances, which is the legal test. So in failing to even consider the options available to him, which range from obviously a slap on the wrist to a dismissal for gross misconduct, but in failing to consider all of the circumstances and all the options that were available to him, i.e. effectively putting his blinkers on and proceeding straight to dismissal, he was in fact dismissing my client unfairly. So that is, I hope, a snippet of information which people may be able to use to their advantage if, for example, during a dismissal hearing for gross misconduct, their employer has, for example, said the words, "I have no choice but to dismiss you." And it's a common trap that lots of employers fall into.